There is only one difference between dream and aim. Dream requires effortless sleep, and aim requires sleepless efforts. Sleep for dreams and wake up for aims. Good evening, ladies and gentlemen. Welcome to ULC Special Lecture Series. I, Vinayam, student of University Law College, consider it my proud privilege to be the master of ceremony for today's session. It's my pleasure to extend a cheerful welcome to the phenomenal, electrifying guest, brilliant faculty, and magnificent participants for joining us virtually. Pandemic can shut down colleges, but the hunger to learn cannot be taken away. And to fulfill that hunger, our college initiated ULC Special Lecture Series from 19th of July 2020, and now with much pride we are hosting the 8th lecture of the ULC Special Lecture Series. It's an evening filled with desires, hopes, and dreams we all share. I am delighted to extend my warm greetings to the patron of the event, Professor Dr. K.R. Venugopal, Honorable Vice Chancellor, Bangalore University, Bengaluru, and the hosting committee of the ULC Special Lecture Series under the guidance of dynamic Professor Dr. Suresh V. Nadagoudar, Principal, University Law College, Bangalore University. Professor Dr. N. Dashrath, Chairman, Department of Studies in Law and Dean Faculty of Law, University Law College, Bangalore University, and all the faculty members of University Law College and Department of Studies in Law. Now, with much pleasure, I request our esteemed principal, Professor Suresh V. Nadagoudar sir, to welcome the guest and gathering.
Good evening, everyone. Dear esteemed guest speaker, Mr. Sai Prakash, Sai Deepak, Honorable Vice Chancellor, Bangalore University, Professor K.R. Venugopal is shortly joining us. Esteemed colleagues, President and respected members of the Alumni Association of University Law College, esteemed advocates, Shri Basavaraj and others who have joined us, and all the guests and participants, dear students. Indeed, we are very happy and privileged to have Mr. Sai Deepak, a very young and dynamic advocate who has made his name and fame throughout the country by appearing in few important cases which have made a lot of news throughout the country, particularly the Sabrimala case and also Padmanabha temple case, which have been decided very recently by Honorable Supreme Court. And indeed, as the number of participants is already more than 200 today, it shows that Mr. Sai Deepak is a very popular speaker and he has many fans everywhere, particularly even in our University Law College. On this occasion, I extend a very warm welcome to Sai Deepak on behalf of Bangalore University and University Law College. Welcome to you, Sai Deepak.
Thank you. Thank you.
So I also take this opportunity to welcome our Honorable Vice Chancellor. He is an eminent academician and an administrator who will be joining us very shortly as he is busy with another important program. And he is always with us and he has been encouraging us for all these endeavors. I welcome him also in his absence. We have our esteemed colleagues, Professor V. Sudesh, former principal, Dr. N. Dashrath, Chairman and Dean Faculty of Law, and all our esteemed colleagues, respected President of our very active Alumni Association, Shri Gautam Chand, who is a great supporter of all our activities, and all the esteemed members of the Alumni Association ULC, Shri Basavaraj, and all honorable advocates who have joined us today, and all the guests who have graced the occasion, and all our students to this program. Thank you very much.
Thank you very much, sir, for welcoming everyone. Just a little housekeeping before we get started. Participants, if you have any questions during the presentation, please type them in the chat box and send it to Naman Wankadari, co-host of the event. We will take them up in question and answer session. The topic for today's session is the genesis of Hindu Code Bill and perspectives on Uniform Civil Code. We are living in those times when we express an opinion where we are always alleged to express loyalty to just one color of the flag, or if we express an opposing view, we are labeled to be expressing our loyalty to another color of the flag. These are the times where we randomly pass comments and statements without any erudition and research. And as an inspiration to our generation, I take this proud privilege to introduce someone as prolific as J. Sai Deepak sir, who is having an illustrious career as a lawyer and as a jurist. J. Sai Deepak sir is an engineer turned litigator practicing as an arguing counsel before the High Court of Delhi and Supreme Court of India. Sir graduated with a bachelor's degree in mechanical engineering from Anna University in 2006 and a bachelor's law degree in law from IIT Kharagpur in 2009. I would like to bring it to the notice of the audience that in what can be termed as one of the rare instances, Sir's article authored during his student life was read by the court to decide upon the matter. From July 2009 till June 2016, Sir was a litigator at the NCR-based firm Sai Krishna and Associates. He was an associate partner at the firm when he quit in June 2016 to set up independent practice as an arguing counsel. His practice areas include civil, commercial litigation, constitutional law, and competition law. Sir has played pivotal role in cases like Sabarimala case, Padmanabha Swami temple case, and Jagannath Rath Yatra case, and has appeared before the Supreme Court in many other significant cases. He is also the special counsel for the state of Madhya Pradesh in the ongoing dispute seeking inclusion of Madhya Pradesh as part of Basmati geographical indication. Sir writes on the blog The Demanding Mistress on issues concerning civil commercial litigation. He also writes in the blog Yukti regarding constitutional law and contributes columns to various national dailies and magazines. Sir is prominent for his indic views and his ups lies in his citations of various authorities to support his views and understanding of the subject matter. He is being considered as inspiration, not just by law students and members of legal fraternity, but people across the spectrum admire Sai Deepak sir for his simplicity and his ability to elucidate the most complicated legal concept in layman's terms. Sir, it's an absolute honor to have you with us. I now request you to address the gathering. Over to you, sir.
Uh, Thank you for giving me such a warm welcome. And I'm really grateful to the organizers, especially the authorities of the University Law College, for giving me an opportunity to interact with students from Karnataka largely. Uh, I say this not with a false sense of modesty, but with a lot of respect that I have typically found people coming from Karnataka, especially any cross section of audience from Karnataka, extremely erudite and well informed when it comes to issues of national interest. Any lecture, talk, or interaction that I have had the opportunity to participate in Bangalore or even in other parts, let's say tier two cities of Karnataka, I found an extremely enlightened audience, an interested audience, which takes an active interest in issues of national interest. So I'm very, very happy that I get to interact with your students once more. Uh, so what I will do as part of this is explain my own transition in terms of my views on this particular subject so that I place before the students at least one live example of someone having changed his position very, very publicly because of further reading and not because of any other considerations. So if you go to this website of this popular portal by the name Swarajya, you will find a lot of pieces written by me until 2011, wherein I actually wrote in support of the Uniform Civil Code. And I actively advocated as to why a Uniform Civil Code is important for what I felt was Indianization of the Indian people through, let's say, bringing some amount of uniformity and harmony in Indian personal laws or personal laws of various communities. Subsequent to that, as I started reading more, especially when I read this fantastic piece written in the Economic and Political Weekly by Shri Madhu Kishwar, titled Codified Hindu Law, Myth and Reality in 1994, it served as a trigger for me to start revisiting my own opinions on this particular subject. And I asked myself if my knowledge as a lawyer was sufficient for me to form a fairly informed opinion on this particular subject without understanding the composition and the structure of the Indian society across the board. Because frankly speaking, I don't think there is any other country which has this kind of diversity, which has this kind of history, and whose circumstances have been extremely complex and complicated. Therefore, I asked myself if unifying the country through a uniform civil code would lead to unity or greater, let's call it, divisions and fault lines in the Indian society. But most importantly, I asked myself, what would its impact be on certain very, let's say, specific identities which are close to our hearts? So there's a decent chance that some of the things that I say, people may find it slightly provocative, but the intention is not to provoke people unnecessarily, but the intention is to provoke people into thinking. So kindly take my questions and statements in the right spirit. And as always, I'm always open to questions. Any question, I really don't have a problem as long as the content is clear and the tone is civil. I'm happy to take questions of any kind. See, one of the things that we have to ask ourselves is the country's composition, at least according to the last census, has about 80% of Hindus and 20% of other minorities and other communities put together. Now, when the Hindu code was initially introduced during the Nehru period between 1955 and 56, with Dr. Ambedkar playing the role of a law minister based on several committee reports of 1941 and legislations during the colonial period, so on and so forth. One of the things that the Nehru government effectively faced was intense opposition to the introduction of the Hindu code. But what was the purpose of the introduction of the Hindu code? What was the intent that was sought to be achieved? And what has been the impact of the Hindu code is something that we have to consider. Now, the person who was interested in introducing the Hindu code was Shri Jawaharlal Nehru, who effectively viewed the Hindu society or the Indian society as a complex maze. He saw it as a huge jumble lacking in any kind of uniformity. And for him, the Indian society represented the textbook definition of chaos and anarchy. So he felt that there is no similarity, there is no uniformity. It's going to be such a huge problem doing justice to various personal laws, including marriage, maintenance, succession, so on and so forth. And that was his basic approach. And therefore, he decided to embark on this particular project with, let's say, with the active support of Dr. Ambedkar, on how do we try and harmonize, at the very least, the laws of Hindus, because if 80% of the population itself has different forms of laws and different sets of laws, it doesn't bode well for Hindu unity or let's say for Indian unity, was effectively his position. It's surprising that for someone who did not have too much of faith in Hinduism or in Hindu tradition, he claimed to work on Hindu unity. That was his basic position. And when opposition started asking him, and several members of the Hindu community started asking him as to why he was exclusively interested in interfering with the personal laws of the Hindu community, he made the statement, I am a Hindu. If I don't take an active interest in Hindu affairs, in whose affairs will I take an active interest? That was the statement made by Shri Nehru to support his position for a Hindu code. Now, it is surprising that Shri Nehru is never accused of being unsecular, despite having made this particular statement in support of a legislation which allowed him to interfere with the Hindu way of life. Because given the recent controversy that surrounded the visit of Prime Minister Modi to Ram Janmabhoomi for the Bhumi Pujan, where questions were asked as to how could he visit this particular place on such an occasion, given his role as the Prime Minister and given his designation as the Prime Minister. One has to merely look at history as to the kind of justifications given by Shri Nehru to justify his interference with the Hindu society. And his very first instinctive defense was, I am a Hindu, why can't I interfere? That, despite holding the designation or the position of Prime Minister. Okay, so this is not the first time that people have invoked their religion despite holding a secular office or a secular designation. So this is something that I thought was an interesting piece of factual information that students must be made aware of, because the current discourse and the manner in which Mr. Nehru is discussed as the fount of all that is secular in this country and the fount of all that is rational in this country is usually busted when you actually examine his conduct a bit more. Be that as it may, this is not about Mr. Nehru, and this is about Mr. Nehru. It's a yes and no in different ways. What is the issue all about? See, my own reading of history and my own reading of civilizational issues, and as limited as it may be and as uninformed as it may be, tells me that the Hindu society is largely a conglomeration of multiple identities. And the Hindu society, barring certain elements of commonality, is as diverse as it gets, because it is an organically evolved society over a period of at least 6,000 to 7,000 years, where multiple communities professing devotion to different forms of deities have become part of this group gradually. And most people don't even realize that the caste system has played a significant role in inclusion of several jatis and communities as part of the Hindu society over a point of time. In fact, if you read active history written by indigenous scholars, both in native languages as well as in English, prior to the, let's say, advent of other religions, the Abrahamic religions from the 7th century onwards in India, the Indian society effectively represented an extremely fluid society where the caste structure translated to inclusion of several communities into the Hindu fold or the Dharmic fold as part of Sanatana Dharma. And their positions kept going up and down during the course of societal transition. So one, there is a very direct relationship between jati identities, their position as part of the Hindu caste structure or the Varnashrama structure, and the personal laws which are observed by various communities, because a significant amount of personal laws observed by various communities are not necessarily traceable to Dharma Shastras, but are traceable to the customs that each community has followed for several thousands of years. And some of these customs have continued right from the time of their inclusion in the Dharmic fold till today. So there is an unbroken continued chain as far as these traditions are concerned. Which is why, if you look at the manner of identification of an average Hindu, he first identifies himself with the immediate community, with the closest community possible, with whose his interaction is on a daily basis, and with whose traditions he identifies. His identity as a Hindu comes perhaps at the second level or the third level, but his primary identity is either based on his caste or based on his language. And I'm not saying this in a negative sentiment, I'm merely saying that this is how the Hindu society has organized itself over thousands of years. And what this also tells us is that, contrary to popular perception that the Hindu society does not believe in, or the Hindu religion does not believe in conversion, what people don't realize is that caste as a structure has played a significant role in Hinduism gradually assimilating other forms of worship as part of its fold. And therefore, over a point of time, what has happened is certain deities which have been worshipped by certain communities have become part of the Dharmic fold, and they have been given a specific status as part of the Hindu society. Okay. So caste, or let's say for a moment, let's remove the word caste, jati, varna, and personal laws. This three-tier matrix, so to speak, has effectively played a role in the gradual assimilation of multiple faith systems as part of the Hindu Dharmic fold, or the Sanatana Dharmic fold, which is why the concept of a sampradaya, or the concept of achara, and the concept of custom have such immense value as far as the Hindu tradition is concerned. Because in the absence of any codified law, what the Hindu automatically falls upon is the received wisdom of his ancestors, which is practiced in the nature of an achara, or which rises to the level of a sampradaya. And the closest equivalent or translation to sampradaya in English would be tradition. Okay. So this is effectively how the Hindu society has evolved over several centuries and perhaps millennia, according to me. And there are several authors who have actually made this particular case, that contrary to, let's say, the predatory form of proselytization or conversions which are observed by certain other faith systems, where one deity is completely replaced by a central deity and one organization is completely replaced by a central organization, and you're expected to owe your allegiance to that central organization and to one deity, what Hindu society or the Dharmic society has done over several decades is that those deities which are worshipped by different communities are included as part of the Hindu pantheon or the Dharmic pantheon without replacing them with anybody else. So if anybody visits Shri, In Shirdi, there is a very popular temple, not the Shirdi Sai Baba temple, but the temple of Khandoba. Okay. And the Khandoba temple, if you look at that particular deity, it is seen largely as a deity of cowherders, cattle worshippers, and people who are in the business of grazing, pastures, so on and so forth. And the deity Khandoba also has a pet, and the pet happens to be a dog. Okay. And if you look at Khandoba, what traditional Hindu society has done is to equate it with, let's say, somebody like a Dattatreya. Okay. So, what Hindu society has done is that wherever it is possible to find an equivalent of local deities with certain central deities, it tries and gives them that particular form. So, for instance, Dattatreya or Khandoba are also equated with some form of Shiva in one way or the other in several, let's say, Hindu traditions. So, this effectively translates to a different form of assimilation of multiple identities as part of a civilizational identity. So, as opposed to going to a certain place, destroying their places of worship, asking them to abandon the worship of their ancestors, asking them to abandon the way of worship of their ancestors, what the Hindu society or the Dharmic society has effectively decided to do is that you try and make them as inclusive as possible so that they are never ever forced to sacrifice their traditions, sacrifice their personal laws, and sacrifice their, let's say, deities, so to speak. Now, what does this actually mean? The Hindu identity that as we know it today, and the way we see it as, let's say, one single unit, is actually perhaps one single unit with several thousand individual units as part of its traditions. And each and every tradition and each and every community is extremely proud of its origins, is extremely proud of its way of life, and is interested in protecting that particular way of life. What we have decided to do is that we have decided to embark on a project called Let's Unify Hindus, which is a fantastic initiative and according to me is a great and noble initiative. But if unity comes at the expense of diversity, then it comes at a serious erosion of another concept, which is identity. And the more we start doing it, the fundamental moorings and civilizational roots of a certain community are bound to be eroded at a certain point of time. And you're bound to produce people who are rootless, deracinated, have no sense of identity, and at least 2 or 3 generations will go through a phase of confusion, which is exactly what is happening with the urban deracinated Hindu as far as India is concerned. I'm currently focusing primarily on the Hindu issue to connect it to the Hindu Code Bill, and from there I'll go to the issue of Uniform Civil Code. So kindly don't think of it as a talk which is exclusively directed at the Hindu identity. Because Hindu Code Bill effectively is one of the, let's say, preliminary pillars of this particular topic, I'm trying to build a narrative around it. Therefore, for the longest of time, how the Hindu society has functioned is to allow different panths, different sects, and different sampradayas to flourish without any interference or without any intention to convert one from the other. Therefore, within the Hindu fold, you have a significant cross-section of people who believe in the Vedic deities and significant cross-section of people who do not believe in Vedic deities because they have their regional deities or local deities to worship. This is extremely common, not just in southern parts of India, but across the country, this is the case. So the feminine divine, namely the Shakti form of the deity, translates to multiple local deities in different parts of the country. In fact, there is a decent chance that we may not even have access to the original history of such forms of worship, simply because most of these traditions have been passed from one person to another, from one generation to another, in the form of oral traditions, because we are largely a community or a tradition which has survived on oral traditions. Second, the Indian society has been subjected to several, let's say, invasions and let's say wholesale genocides across the country for close to 1200 to 13 years. As a consequence of which, several forms of knowledge and several centers of knowledge have been destroyed systematically, making it difficult for us to understand our own history. In fact, there is a decent chance that we are building castles in the air and we are actually trying to build a logical edifice in the absence of concrete evidence, because that evidence has effectively been lost to history. Which is precisely why today when we have discussions around caste, when we have discussions around the caste system or discrimination around jati, kula, varna and whatnot, our discussion is so uninformed and without any basis that there's a decent chance that in the absence of indigenous sources, we are merely mouthing whatever the white man wrote about us. Therefore, our primary reference points are in English, written by the Westerner or the Britisher, who effectively saw us as savages and who assumed that every tradition of the native Hindu society is a tradition which is rooted in superstition. Therefore, the current education system, both in history when it comes to caste and religion, mouths the very same colonial nonsense that was written about by the British man about us. And the current education system continues to perpetuate the same knowledge system. Which is why, when you look at how the Hindu traditions were treated and looked down upon by the Nehruvian system with respect to remarriage or let's say the concept of succession and whatnot, they consciously assumed the notion that all they have to do with the Hindu society is to reform the Hindu society, and therefore they made this "let us reform the Hindus" project. So the Hindu Code Bill, according to me, effectively is an unwarranted reformist movement. There were certain aspects which are incidentally good. There were certain aspects of reform which were necessary. I don't deny that everything was great and everything need not have been reformed at all. However, if it happens to be a democracy, and if it is supposed to be a secular democracy, a government cannot assume at the outset that a certain practice is superstitious until proven otherwise. The government must first put itself in the shoes of the practitioner and ask them the basis of a certain practice and involve them in a dialogue before any interference or legislative interference is initiated upon with their way of life, with their personal laws, and with their, let's say, with what they believe is their tradition. Over a point of time, what has happened is that we have decided to compartmentalize religion as having two different baskets. One basket is purely religious, where we go to the temple, where we have a deity and we worship. And the other basket are issues relating to marriage, succession, so on and so forth. Unfortunately, a reading of history and religion will tell you that you cannot create such compartmentalized baskets. Personal laws in most communities are inevitably and invariably traceable to the religion and to religious practices and to religious beliefs. Therefore, when you try and separate religion from personal laws, you are going to commit a mistake which has no basis in history, which is completely ahistoric. And in the process, you're going to limit the scope of religion and also dilute the place of tradition in the life of an individual as well as in the life of the community. So my primary criticisms against the Hindu Code Bill in the manner in which it was introduced is less about what was the object of that particular initiative and more about the manner in which that particular initiative was shoved down the community's throats without any kind of participation. Most of the initiatives that were undertaken between 1947 and 1964, that is the first 17 years of independence, especially under the Nehruvian dispensation, lacked any form of participative policy making because they assumed that we have inherited 33 crores of uninformed, unlettered, savage barbarians who don't understand English and therefore they are illiterate. The test of literacy was whether or not you were in a position to relate to the white man or the Britisher's point of view. Okay. And therefore, significantly, what happened. Okay. So, I think the last point I was making was about 33 crore people. Okay. So, the point I was making was that when a dispensation effectively assumes that the people who have elected it have no brains and do not have the wisdom or the viveka to effectively decide for themselves what is superstitious, what is progressive, and what is modern and what is contemporary, it automatically results in a situation where policies are made top down without any kind of participation from the grassroots. So the manner in which the Hindu Code Bill was passed, according to me, raises two very, very important issues. And perhaps these are questions of research for law students who may wish to try and understand. One, how much of a discussion was undertaken with the members of the community and stakeholders before the project was mooted or initiated? What is the extent of discussion or debate that took place in on the floor of the parliament when the Hindu Code Bill was effectively introduced by way of series of legislations? and what kind of opposition was presented to it, what was the response of the government to that particular opposition. So this, according to me, would be a textbook example to understand how the country's first dispensation treated its own people, and whether it was any different from the manner in which the colonizing power prior to India becoming independent treated the people of India. That's one question that needs to be asked. Second, the other question that we also have to answer is, in light of Article 26 and Article 29, how is it possible to actually think of a unified Hindu code bill in the first place? And there is a reason I bring up these two articles. First is that Article 26 effectively protects the religious denominations and their, let's say, their religious affairs, including their institutions. Second, Article 29 protects the culture, the language, and the script of any class or section of Indian citizens, not necessarily religious minorities. The language of that particular provision is crystal clear in this particular regard, and its interpretation by the Supreme Court in TMA leaves nothing to imagination, that the right under Article 29 is available to both linguistic and cultural minorities and not necessarily limited to religious minorities. In fact, there is no reference to religious minorities in that particular provision. It speaks of language, script, and culture. Religious minorities find specific reference in Article 30 and not in Article 29. So you have one provision that effectively preserves the religious affairs of denominations, and you have another provision of the Constitution which effectively preserves the culture of a particular community and any section or any class of Indian citizens. If these two provisions, which form part of Part 3, provide protection, a very fundamental protection to religion as well as way of life, don't you think that a bid to unify or a project to unify and harmonize personal laws effectively comes at the expense of Articles 26 and 29 of various communities, not just one particular community? So what does this fundamentally take you to? Is that over a point of time, the Indian state has effectively treated Hinduism as another form of an Abrahamic religion, or the Hindu society as just another Abrahamic society or a Judeo-Abrahamic society, which it is not. Fundamentally, as a civilization and as a faith system, so to speak, the single biggest reason that the Hindu community respects diversity is because it is the product of multiple and diverse identities. So according to me, Article 25 being part of the Indian Constitution is no big deal, because almost every jurisdiction which is fairly civilized respects the freedom of thought and conscience and religion and whatever it may be. But Article 26 is, according to me, the single most important feature of the Indian Constitution, because it is a clear recognition that not only are there multiple faith systems, but there are multiple denominations and multiple traditions even within the same faith system. And primarily you're looking at the Hindu faith system or the Dharmic faith system, which has multiple traditions or sampradayas. Therefore, any attempt to unify personal laws or to harmonize personal laws in the name of Hindu unity is effectively going to come at the expense of the immediate identities and the immediate traditions of several communities. That's point number 2. Point number 3, the assumption that standardization is good for its own sake is something that needs to be challenged. Why is it that you need to standardize something? What is the dying need to standardize and harmonize laws? What is it that is problematic? If there are certain problematic aspects of certain cultures or certain practices which you feel are incompatible with current day mores and values and norms that we adopt and what we take for granted, even then the legislature or the government must at the very least give members of that particular community an opportunity to explain their position and to defend their tradition. What has happened, I think, in the last 70 years is also the equation of tradition with a regressive behavior and modernity with a progressive behavior. Therefore, whenever somebody stands up to defend a certain tradition of a community or of a religious institution, The first assumption is he is traditional, therefore he or she must be orthodox, therefore he or she must be regressive, and therefore they are not fit to live in a modern society, and their value systems are outdated and anachronistic. There are any number of countries and jurisdictions where this does not hold water and this kind of an equation has no value. But it is peculiar to the Indian society where the word tradition has acquired a negative connotation over a point of time. The word sampradaya has acquired a negative connotation over a point of time. And we constantly look for killing diversity in the name of unity and harmonization. So therefore, this is something that needs to be understood at a very, very deeper level, at a philosophical level. This issue has a bearing not just on aspects relating to maintenance, succession, marriage, and let's say other issues relating to personal laws. It also has a bearing with respect to how we perceive religious institutions and religious practices. It is impossible for us to compartmentalize this and treat them in silence. If our approach with respect to tradition is negative in one context, it is bound to be negative equally in another context because we have fundamentally equated tradition with anti-modernism, and therefore we have come to the conclusion that tradition is not perhaps contemporary and is best limited to certain ornamental areas. This is something that I've been trying to talk about and I've been trying to address as much as possible, because as a post-colonial society, Bharat has still not let go of the colonial lens in the manner in which it looks at its own ways of life, and also how it legalizes these ways of life and the manner of legal interventions that it introduces with respect to these ways of life. Today, Bharat perhaps may think of itself as a much more advanced society or a much more liberal and open-minded society compared to 1947. But it is also perhaps a fundamentally rootless society, at least urban parts of Bharat, because urban Hindus and members of the majority community have no sense of community. They're extremely individual in their approach and they're extremely individual in their mindsets. And therefore, a sense of community, which was existing thanks to the presence of a certain structure, has effectively been eviscerated. And the introduction of the Hindu code has played a significant role in that. And according to me, the introduction of the Uniform Civil Code will create a greater havoc and will effectively destroy all structures as we know it. Other communities may perhaps be affected less, but the Hindu community is bound to be affected even more for one important reason. Every institution of civilizational value, of community value, of cultural value, of religious value, which belongs to the Hindu fold, has effectively been rendered a useless organization or an academic organization, or it has been rendered toothless to a significant extent. As a consequence of which, the Hindu society has very few independent institutions which are in a position to protect its own interests, or which are in a position to fight for and be vocal about the Hindu interest. And therefore, the Hindu society has become largely more dependent on the state than other communities. And the state in turn has decided to treat itself as the guardian of the Hindu society in a very negative way, while constantly protecting the religious autonomy, the personal autonomy, and the institutional autonomy of other faith systems. So here is a crystal clear textbook example of one community's vital institutions being completely defanged, its ways of life being defanged by judicial intervention and legislative intervention, the Hindu code representing such a negative form of intervention. And consequently, the Hindu society has nobody else to look out for its interest and depends on the state. But the state is not even reciprocating that degree of dependence and is busy protecting the autonomy of other institutions and other faith systems. This incongruity has no equivalent or has no comparable in any other jurisdiction. Only in India, perhaps this is happening. And now I'm seeing a lot of people constantly mouth the need for a uniform civil code under the assumption that a uniform civil code will equally lead to a situation where other communities, their hold on their religious institutions will be loosened, or the hold of their religious institutions on the community will be loosened. I don't think that's ever going to happen, because by design, those communities are intended to be dependent on their religious institutions and on their own community more than on the state. Whereas the Hindu society, which had its own hierarchy or which had its own structure, so to speak, and which had its own organizational and institutional structure, has been completely diluted and eviscerated. Why is this important? Why am I focusing on this so much? Because whether you like it or not, if 80% of the country lacks a sense of cohesiveness and lacks a sense of unity because its institutions have been completely diluted and its ways of life are constantly under challenge, then it poses a threat to the country, and especially in a country like India, which faces so many challenges from a civilizational standpoint, from a demographic standpoint, and from, let's say, a geostrategic standpoint. It has serious implications. I dare say, and I'm going to make this bold statement, as offensive as it may sound, a uniform civil code, unless and until it is done with the discussion of, or let's say with the participation of members of the community, is bound to have an impact where it finishes whatever remains of Hindu institutional freedom and Hindu way of life, as a consequence of which the overall, let's say, role played by Hindu institutions and the Hindu community in national polity will also be affected. And this effectively means the country is no more safe for and will no more be in a position to safeguard the interest of at least 80% of its population. So the logic that Nehru gave, which is to say that if 80% of the population is safe and is unified, then that will bring about greater integration of the society. I agree with that particular logic, but I only disagree with the fact that a uniform civil code will achieve that particular goal, because I don't believe a uniform civil code will achieve that particular goal. Therefore, in light of the experience of the Hindu Code Bill and the manner in which state organs have interfered with Hindu institutions, the one thing that I have learned as a consequence of my reading of this particular history is that as a member of this particular community, having seen how my community's rights and traditions are shortchanged in the name of unity and they're shortchanged in the name of harmonization and standardization, I am fundamentally suspect of the Indian state when it comes to its interventions with my way of life, especially when it comes to my traditions and personal laws. So if, let's say, people like me have to be convinced that a uniform civil code is good for the country, I need to see the document to see what does the draft say, what is its ultimate intention, what is its ultimate goal, and what kind of interference is going to be put as part of that particular structure, and what justifications are going to be given as far as this particular structure is concerned. If people are going to tell me that Article 48 or Article 44 speaks of the Uniform Civil Code and therefore it needs to be implemented or interpreted, then several other parts of the Constitution say a lot of things, including with respect to cow protection and ban on cow slaughter and whatnot. So why are we so particular about certain aspects, and why are we so, let's say, why do we take such an inconvenient position with respect to other aspects? We need to be able to strike a balance. Let me be very, very clear. I'm not necessarily speaking on behalf of other communities, because I believe that other communities are effectively represented. They're in a much better position to protect their interests. And the government is always going to listen to other communities for one reason or the other, because you see, India worships secularism and therefore it has to listen to other people. However, as a practicing Hindu and as someone who understands the Constitution and who's familiar with the manner in which the Indian state has interfered with the Hindu society, I am very, very clear about the fact that unless and until I see the government spell out its specific intention with respect to the Uniform Civil Code, I am neither for the Uniform Civil Code nor against the Uniform Civil Code. However, anything that comes at the expense of public participation, that comes at the expense of, let's say, a participative policy-making process, and that comes at the expense of my traditions and my rights. And by that, I mean the traditions of all Hindu communities and all Hindu jatis and all Hindu sub-identities. Okay, I'm not just referring to any identity that I am associated with. I believe that every Hindu sub-identity is equally valid and has the right to exist. And every institution that is associated with a certain community represents a way of life and a continuity of thousands of years. And any interference with such particular practice in the name of unity, you better have better reasons than unity to actually tell me that that an interference is warranted. Because it is this particular structure that has protected the Hindu society for over 1300 to 1400 years of its tumultuous existence between 780 to 1947. It is this particular structure that has managed to produce a lot of resistance and rebellion to invasions and interference. So if you want to dilute it today, you need to have better reasons and you need to have a better alternative structure. if you're not in a position to offer a better alternative structure, which brings the society together, as opposed to making it, or as opposed to removing all elements of a feeling of community in it, I don't see why I must support it. In fact, while the Uniform Civil Code may have some kind of a sanction under Article 44, if a specific initiative comes in the way of rights under Articles 25 and 26 and 29, communities will have the recourse under the law to challenge any such legislation for violation of fundamental freedoms and for effectively eating into their very way of life. I would suggest that when we read issues such as the Uniform Civil Code, it effectively represents a confluence of three different aspects. First, you need to understand the scheme of the Constitution, the history of the Constitution, that goes without saying. But importantly, what you cannot lose sight of is the history of the conduct of the Indian state when it comes to religious laws, personal laws, and which community has been perhaps at a greater receiving end of the state's intervention. Now, whenever I make this statement, I'm typically told that no, times have changed, and therefore we need to trust the government in power, and therefore we must effectively surrender all our mental faculties at the feet of, let's say, our allegiance to a particular institution or a particular organization. I believe, as someone who has vocally supported several initiatives of the government, because I believe in those initiatives and because I have an issue-based approach, I cannot effectively be asked to surrender my mental faculties or my ability to question unless and until I have the right answers which address my very legitimate concerns as far as my community and my identity is concerned. So I'm very, very clear about the fact that it is not enough of an answer to say, trust the government. I need much more than that, because at the end of the day, every political organization at best has its sights set on the next election or the next, let's say, outing in the hustings. People like us, and especially members of the community, cannot give up the identity. And for us, it's a matter of civilization. It's a matter of multiple generations, because we are interested in passing on this identity to the next generation and the next generation, and for eternity if possible. And given that our interests are of a greater time span than the interest of a political party or a government, which rarely goes beyond 10 or 15 years, which is not the time cycle for a civilization, I need very clear, convincing answers for me to be able to jump on this bandwagon of the Uniform Civil Code. Given that over the last few days, the city of Bangalore has seen a very, very troubled phase and a disturbing phase, I actually am fairly active on Twitter, and I read on Twitter some geniuses writing, the Uniform Civil Code is effectively the answer to this particular situation. I don't see how the Uniform Civil Code is even remotely connected to this situation, because anybody who is intent on violating the law in this country, especially if he happens to have political backing and he has the numbers to disturb the law and order at will, and he doesn't even spare the law and order establishment, and even policemen are not safe, I don't see how a law such as the Uniform Civil Code will effectively come to protect us from such people, or to effectively prevent such people from indulging in this wanton act of violence and destruction. We need to be able to get out of this, how do I say, mindless meandering that the Uniform Civil Code is effectively the answer to everything. The law is not the answer to everything. Societal response and institutional autonomy and institutional freedom and institutional strength ultimately is how societies function. Governments are extremely myopic, especially in a democratic setup, because they're constantly in, let's say, taking part in a fight to remain in power. They have no other option, because on a day-to-day basis, they have to deal with headlines. They have to deal with the allegations of the opposition. They have to deal with a lot of rebellion inside, a lot of factionism inside the government and whatnot. I'm just talking of general governments. In most places, this happens. No party or no government is an exception to this. Do you consciously and truly expect such a government, which has its hands full in constantly firefighting 24/7 in every direction, to pay attention to the interest of the community, to pay attention to civilizational concerns, to pay attention to parampara, sampradaya, and whatnot? I don't think so. Ultimately, it is for the society to look out for these issues, and it is for the society to preserve its autonomy on these issues, so that the government plays a minimal role in these aspects, and the government primarily limits itself to issues of secular nature and secular interest. Unless and until the government has a civilizational vision and has effectively the political will and the strength to implement that particular vision, I have no interest in ceding my community's autonomy or my institution's autonomy at the feet of or at the hands of any government for that particular matter. And I don't think anybody can convince me otherwise unless and until they're able to give me very concrete answers and they have some kind of data to back it up. Unless and until there is a clear factual example that counters my apprehensions which are rooted in history and my apprehensions which are rooted in the treatment of several communities of the last 73 years, I have no interest and I cannot be expected to trust any dispensation with respect to civilizational interests. So uniform civil code is not a question of secular aspects of Indian society. A uniform civil code is inextricably tied to religious aspects, to personal laws, because personal laws can never be dissociated with the community's religious beliefs and customary practices. So this fundamental understanding is very, very important. And here I have to make a very, very important caveat. And there's a decent chance that I may hurt a lot of urban people here. People who live in cities have a kind of a superiority complex where they assume that they understand the concept of a civilization better and they know better than their counterparts from the village or the district when it comes to what is good for the society. Frankly, I believe that is an opinion that has no basis either in facts or logic. Urban, let's say people who live in urban centers have very little sense of community, have very little sense of identity. Perhaps they may shout and shriek and scream on Facebook on a couple of occasions, but when it actually matters and when they're actually supposed to make their presence felt, especially in a situation like elections, people from the urban centers are the least reliable. Therefore, those sections of the population which don't seem to actively take part in a critical event such as elections are certainly not well placed to dictate to the rest of the society as to how it must behave, merely because this part of the society can speak in English. That doesn't make it superior, that doesn't make it wiser, that doesn't make it more intelligent. In fact, people living in urban centers have very little understanding of the life in village or district or the social structures or the social realities, because we don't understand anything beyond caste discrimination. We assume that caste is equal to caste discrimination. We don't understand how these communities live with each other in these places. Just as we don't understand much about the caste, we certainly don't understand the value of personal laws in these places, in non-urban centers. Why non-urban centers? If there can be a clear cultural distinction between Bengaluru and Mysuru, or between Bengaluru, Mysuru and Mangaluru, then go to deeper parts of Karnataka or deeper parts of the country, you're bound to see a lot more allegiance to tradition, a lot more allegiance to traditional societal structures, and a lot more allegiance to family values as well. The Hindu Code Bill has effectively led to the breaking up of the Hindu family structure of the last 70 years, which has had very significant societal negative ramifications for us to see everywhere. I'm not saying that the concept of a widow remarriage is wrong. I'm not saying that perhaps people should have the option of walking out of an unhappy marriage. However, the concept of divorce, which was completely unknown to the Hindu marriage, and because the Hindu marriage is effectively a sacrament and not a contract, we have decided to give options. Now, some may say, so what is so wrong with it? It's an option that it must be available to everyone. If you look at it from an individual's perspective, yes, obviously such rights must be available, because why should somebody be expected to suffer an unhappy marriage or whatnot, or why shouldn't somebody have the right to do something else? But if you were to simply look at how the Hindu Code Bill has had an impact on the overall society, the fact is it has resulted in fragmentation of the Hindu family structure. And if history were to teach us anything, the central unit or the most important unit and the fundamental unit of the Hindu society is the family, and then the immediate community, and then everything else. So it is in these concentric circles that this particular community has functioned over thousands of years. And the legislative intervention without any kind of participation or any kind of consensus, or let's say a consensus building effort on the part of the government, has affected the most central unit and the most fundamental unit of the Hindu society, namely its family structure. I certainly believe that laws which oppose dowry and penalize dowry must be in place. I certainly believe that laws which effectively sanction and penalize, or rather which penalize domestic violence, must be in place. I am not going to justify anything that results in commission of violence against members of any gender or members of any particular community or individual rights. However, over and above these discussions, what has happened is an extreme tilt towards an individualistic approach towards rights without understanding that Indian society respects a balance between rights and duties. And just as you have rights as an individual, you also have certain duties towards the rest of the community. So personal laws are not just meant to protect the individual space, but they're equally meant to protect a community's identity over generations. So when you interfere with personal laws, you are interfering with transgenerational rights and transgenerational duties. This is something that Indian policymakers barely understand. Their understanding of these issues is extremely superficial and shallow. I don't think they have read as much. I don't think they have been informed as much. Therefore, others will have to take it upon themselves to basically say, these are the underpinnings and the basis for the Hindu society or the Indian society. If you don't understand them, kindly inform yourself of these positions before you decide to pontificate from the top that a uniform civil code is absolutely important. So therefore, the reason why I decided to present Hindu Code Bill and the Uniform Civil Code as a combined topic is to use the Hindu Code as an example to show how the Indian state has behaved in a certain fashion. And if that is the history of the Indian state, how is it going to treat the topic of Uniform Civil Code, not just with respect to the minorities, but also with respect to the majority. So all these days, whenever the concept of civil code has been discussed, the fear has been that it is against religious minorities or religious minorities will be the worst affected. In fact, my fear is that cultural minorities within the religious majority will be the worst affected when it comes to the Uniform Civil Code, because they do not have the veto power to stand up to the government and say, sorry, you're affecting us. Because the government doesn't treat all minorities equally. Some minorities are more minority and more equal than other minorities. That has been the manner in which the Indian government or the Indian state has behaved. So to protect these rights of supra minorities within the Hindu community, it is important to actually understand that cultural laws, that personal laws are tied to ways of life, and they're tied to religious aspects and to customs. And therefore, any such interference is bound to affect rights under Articles 26 and 29. I'm giving a tangible, concrete constitutional peg to these concerns. So unless and until a uniform civil code is in a position to do justice to these forms of rights and these sets of rights which the Constitution effectively recognizes, because you have to see, Article 44 forms part of that particular part of the Constitution, which is non-justiciable, whereas Articles 26 and 29 form part of Part 3, which is justiciable and which can be enforced through Article 32. So the state has a greater burden to prove why a non-justiciable aspect of the Constitution must prevail over justiciable and enforceable parts of the Constitution. This is something that we must try and ask. So as someone who supported Article 370, as someone who supported the CA and who is in principle comfortable with the concept of the NRC, when it comes to the UCC, I need clear answers. I don't think I have those answers yet. I'm willing to take questions now, please.
Thank you, sir, for giving your wonderful insights. It was
So
packed
we
with-
have our Honorable Vice Chancellor joined us, and I extend a very warm welcome to you, sir, for this program, and thank you very much for gracing us, sir.
Namaskara. I was hearing to Sai Deepak, very enlightening address. Thank you, sir. I'm here. I'll also be able to talk. I will not be able to talk and match whatever you have said, but I'll give my thoughts about it.
Thank you, sir. Thanks a lot for coming, sir.
Okay. Yeah. So shall we take up some questions and afterwards you will address, sir, or now you will address?
Questions.
Okay. Naman can go ahead with questions.
Thank you, sir. Thank you, sir, for giving your wonderful insights. It was packed with bucket loads of information. Your research, your depth of understanding on the Hindu Code Bill and Uniform Civil Code, your ability to present the subject in such an interesting way produced one of the most memorable evenings. Sir highlighted that law is not always the solution, but the mindset of the society is. I am sure all the attendees would have learned a lot. Now, I invite Mr. Naman Wankadari, student of University Law College, Bangalore University, to take up the question and answer session. Over to you, brother.
Thank you very much, Vinay. Sai Deepak sir, at least I perceive it to be so. So let me begin with a caveat. There are avalanche of questions awaiting, and with your permission, sir, I would like to begin.
Sure.
So the first question will be by the chairman of the Department of Studies of Law, Professor Dr. N. Dashrath sir. He would want to ask you an oral question.
Yes, please.
Yeah, very good evening. Am I audible, sir? Very
Yes,
good
sir.
evening,
Yes,
sir.
sir.
Very good evening, Sai Deepak ji. Very good evening, Honorable Vice Chancellor, sir. Very good evening, sir. Sir, am I right if I say that the intent and content of the Hindu Code Bill mooted by Dr. Baba Sahib Ambedkar was more emphasis on equality rather than on uniformity? Am I right in this way to think, sir?
I would, am I audible, sir? Can I hear you? Can you hear me?
Sure. Thank you.
Yeah, okay. So while the stated intent was equality as opposed to uniformity, the argument that I am presenting is equality when it comes to gender rights is something that nobody can have a problem with. There is no argument with equality on that particular front. However, when you decide to codify personal laws, what you do is to shackle personal laws, and this is where I will draw from one of the arguments that effectively is taking shape in other jurisdictions as well. That when it comes to personal laws, one of the reasons that codification through legislative intervention is largely frowned upon these days is that personal laws are the product of custom, and therefore with time the community effectively comes up with its own responses and its own solutions. And therefore over a point of time, let's say maybe 30-40 years down the line, the community changes most of these aspects according to its own practices through what is known as a consensus. So in fact, just last week, a few days ago, I had a discussion with a Swamiji from Ramakrishna Ramakrishna Center, Ramakrishna Mission from Gadag, Karnataka, okay, where I was addressing law students on caste, religion, and the constitution. And I ended up asking him, how does a community change its position with respect to its personal laws, and what has been the traditional Hindu way of going about it? To which his answer was, every decision is largely based on two aspects. One is necessity, and second, acceptance by the community or the majority of the community over a certain point of time. And that is how achara attain, or let's say the concept of an achara comes about, and that is how the concept of a sampradaya also comes about. Okay. So when a certain practice goes out of fashion and is no more relevant to a certain point in time, it is the current belief that the only way to do away with that certain practice is by codifying it and then by legislatively amending it, as opposed to leaving the community to amend its policies as it goes about. Now, as far as the Hindu society is concerned, when we clearly recognize that the concept of a smriti is transient and it is not immutable, then smritis and practices are effectively meant to change over a certain point of time, and they're bound to change over a certain point of time. We don't believe in the concept of one law is good for all time to come. That is why we clearly strike a distinction between the concept of a shruti and the concept of a smriti. In that particular situation, when you codify a personal law, then you're effectively rendering the community dependent on the legislature for any changes. And therefore, you have to constantly go to the legislature for making changes in personal laws. Second, realistically speaking, is it possible for you to say that any legislative process is free of political calculation and political arithmetic? The answer is a no. Therefore, a community's decisions with respect to its personal laws are held hostage to the interest of the politician, who ultimately may or may not choose to support a certain legislative amendment. And if a community wants to move away from a certain practice, it is certainly bound by the legislation, which continues to be operative until it is amended. So this one of the central arguments that has been leveled against codification of personal laws and legislative intervention of personal laws is that in a community or a society like India, which has effectively observed the policy of casting away or discarding a certain practice if it has lost its relevance, even in the absence of a codification, you have shackled this particular society through a codification in the form of a Hindu code bill. In fact, The more you read even Shri Pandurang Vaman Kane's Dharma Shastras, the history of Dharma Shastras, one thing becomes abundantly clear is that a good number of laws, or what we see as laws, were not exactly laws, but description of customs as they existed then. Okay. Therefore, the compilation of practices was more descriptive in nature than being prescriptive in nature. Okay. And therefore, what it accommodated for is diversity even within the same region, and certainly diversity across the scale of Bharat, depending on the circumstances and depending on what is acceptable to different people. Now, we are being told that all of this must be effectively subject to legislative sanction, must be effectively subject to legislative amendment. I still don't see what is the problem there. So their argument is, how do we do justice to all of this, and how do we enforce all of this in the absence of a law which codifies all of this? What is the justice dispensation mechanism that ultimately addresses these issues? And I will cite one of my most favorite examples here. If you look at the state of Israel, different communities have different justice dispensation mechanisms on the front of personal laws. Their secular constitutional courts don't take up the question of personal laws because of two reasons. One, every community has a different notion of what is good and bad from a personal law standpoint, and you can't expect a secular judge to understand the personal laws of every community. Even if you understand, it's not the same as believing in that particular community's practice, because it is a question of personal law. Okay? A judicially trained forensic mind is bound to be significantly detached from the value that a community gives to its personal laws. Okay? And in matters of religion and matter of personal laws, that may not be a great quality according to me, because you will not be in a position to relate to the community's worldview. You will not be in a position to relate to the community's cultural or religious standpoint. Therefore, the one thing that I have certainly believed in is we should decentralize and desecularize justice dispensation with respect to personal laws. And you must try and give as much support as possible to community-driven justice dispensation structures for the purposes of personal laws. And that community can perhaps decide its own future, not just with respect to justice dispensation, but also with respect to whether a certain law has become redundant and useless for a given point of time, as opposed to being dependent on the center. I'll give another supporting answer for this, sir. Bharat, as we know it today, is the congregation and agglomeration of princely states, several princely states, each of them having their own rich traditions, each of them having their own personal practices. In fact, even Karnataka, as we know it today, is the combination of multiple princely states, the Mysore princely state being one of them. So as far as I'm concerned, a fundamental expectation of protecting the cultural rights of religious communities across the country, especially in princely states, was the reason for Article 29 of the Constitution for recognizing the cultural rights of any section of the country. And that stands completely eviscerated, and the constitutional guarantee, which is recognized as a fundamental right, stands violated when you centralize issues relating to personal laws and you make it subservient to legislative action by the Union Parliament. That's where I have a central problem, sir.
Okay, thank you, sir.
Thank you very much, sir. So next question is by the Faculty of Law, Dr. Jyoti Vishwanath, Madam. Please highlight the scope of religion and personal law. Why, as per your secularizing way of life in matters like monogamy, maintenance, succession, will destroy or affect the religion?
So two aspects. I don't believe that secularizing, see, there are two issues. In fact, can you just repeat the question, because there are two strands to it. One is secularizing, the other is?
Secularizing way of life in matters like monogamy, maintenance, succession will destroy or affect the religion.
Thank you. Okay. In fact, this question, according to me, is a textbook example of the urban Hindu who doesn't understand the relationship between personal laws and religion. Okay. In fact, this question proves my point, wherein the urban Hindu effectively believes that thanks to his or her knowledge of the Constitution, it is possible to treat some of these aspects as secular aspects, and religion must effectively be limited to a relationship, a personal relationship between the deity and the devotee. That is not how the Hindu society has functioned, and that is certainly not how these structures have evolved. In fact, that tells me that the fundamental nexus between personal laws and religions has become the subject of collective amnesia. We have forgotten it completely. Over the last 70 years, we have completely forgotten that there is a direct relationship between the two. Let me explain how and why. As students of law and as students of jurisprudence, we understand that certain sources serve as sources of law and certain ultimately translate to the legal edicts themselves. Okay. So for instance, Dharma Shastras in themselves are not sources of law, but they are the law themselves. Okay. But Dharma Shastras are traceable to certain beliefs and a legal philosophy which underlies it. Okay. So a legal philosophy or a way of life is perhaps the underlying source of law or the fount of law. And what we know as smritis and what we know as Dharma Shastras effectively translate to law in action. Even then it is largely, as I said, descriptive and not prescriptive. Now then tomorrow you're going to say, what is wrong if the Hindu society ultimately treats marriage as a contract and not as a sacrament? Okay, two things happen there. One, you are effectively telling me that the state has the right to change my fundamental notion of marriage. Okay. A notion of marriage, which I as a community believe in, and which ultimately I trace not just to the ceremony that is performed, but to the promises I make during the course of the ceremony, which effectively codify and personify my rights under Article 25. Everything that I say during a marriage ceremony around the sacrificial fire is protected by Article 25. Let me be very, very clear about that. And you're telling me that the obligations that flow from that particular religious activity, marriage is a religious activity, it is not a secular activity, which is why you recognize the concept of a Hindu marriage, you recognize the concept of a Muslim marriage. If marriage was a secular activity, then you will abolish every form of marriage and you will only have the Special Marriage Act. But the Special Marriage Act is optional, it is not mandatory. Therefore, you recognize that there's a direct relationship between religion and activities such as marriage. So if marriage has a very clear religious value, you're telling me that everything that flows out of the marital relationship must now be treated as a secular activity or a secular consequence. How can Ganga be religion and Gangotri be secular? That can't be the way it works, right? You're telling me that the source has a certain character, but what comes out of the source is a very different character and which is antithetical to it. That's not how it works. So one, assume for a moment that somebody wants to adopt the secular approach when it comes to marriage, or wants to adopt a secular approach when it comes to maintenance. I will still be comfortable if it is made optional and certain members are given the opportunity to go out of the traditional structure and opt for a secular structure if they wish to. However, you're telling me that I don't even have the right to abide by my religious structure. So assume for a moment that there are two couples. One couple believes that marriage is a contract despite being a Hindu. Another couple believes that the marriage is a sacrament despite being a Hindu. Both of them must not be expected to conform to the same set of rules because their practices are different, their beliefs are different. The one who wants to practice his religion and treat his marriage in accordance with his religion and therefore treat marriage as a sacrament must have the option of doing so. Whereas those who believe that marriage is a secular activity or is a contractual activity must have the right to do that as well. I am not saying shackle any one particular cross-section of the society at the expense of the other. Don't kill the rights of the traditional believers simply because you have to cater to the modern secular person. Give both of them an option to live by their practices, to live by their ways of life. So what does this take you to? If a uniform civil code ultimately becomes optional, and you ultimately allow people to make a transition depending upon what they're ready for and what they're comfortable with, that would perhaps be more democratic, because then the transition from a traditional structure to a more secular structure is the product of individual volition and is the product of consent. But if you introduce it as a mandatory law, which everybody is expected to comply with, then you affect my right to choose between a secular structure and a religious structure that comes at the expense of my rights under Articles 25, 26, and 29. Okay. So I'm not saying that, assume for a moment that I'm a hyper-traditionalist and a hyper-orthodox person, my views must effectively shackle and stifle somebody else's right to choose for a more secular structure and choose a less orthodox structure. I'm saying make it optional. Let both of us have our own options. Let the Uniform Civil Code not become a tool of mandatory coercion is my humble submission.
Thank you very much, sir. So next is Basavaraj sir of Daksha Legal would want to ask you an oral question.
Absolutely, sir.
Mr. Sai Deepak, am I audible?
Absolutely, sir. Please, sir.
Okay. Now, at least as on today, this is what I feel, at least as on today, all penal laws, all special legislations, all corporate laws, all property laws and contract laws are same to all. Okay.
Right,
As
sir.
even the penal laws. Now, the very document of the nation, that is the Constitution of India, is same to all except Article 30, which protects the religious minorities and all. Therefore, instead of this UCC and all this drama, which some people would like to quote the drop of the hat, what I feel is some intra-religious reforms, starting from like sati, child marriage, triple talaq, on the touchstone of essential religious practices should be undertaken either by the judiciary, like done in Shaira Banu, or by of legislation, the erstwhile abolition of child marriages. Therefore, what I feel is when every legislation in this country is same to all, what we require is intra-religious reforms based on one of the tests like essential religious practices, ERP. Would you agree with this?
Sir, I would agree with the proposal, but not the basis of the proposal, sir. Okay.
ERP, you have a problem because
Yes,
I know.
exactly.
I know.
Correct. So one is, see, let me explain my basic disagreement, which is common to all these issues. Okay. My basic disagreement is simply this. A state which professes secularism in a very convenient manner at the drop of a hat cannot be trusted to understand my religion or my practice. And I don't believe that state is any better placed to understand what forms an essential part of my religion, what doesn't form a part of an essential part of my religion. Okay. I'm saying this not about the judiciary, I'm saying this about the state itself. That's point number one. Point number two, the judiciary should certainly not be a part of this activity is my 100% belief. One, because the judiciary is not constitutionally empowered to do so, is my clear position. I am not on the desirability of it. I'm not on whether or not it should do it. I'm saying, can it do it or not? I'm saying the judiciary is not designed to by the constitution to undertake such an activity. Shaira Banu also presents an extremely complex situation and for a different reason. Why? Mr. Kapil Sibal raised an argument during the course of this, this entire hearing that can you treat personal laws as part of laws under Article 13? That was a very important question that he raised, because this question was raised in the case of Narasu Appa Mali versus State of Bombay. That was the very first time that this judgment came out on this particular question. Justice Nariman recognizes the validity of the question, and like a Rahul Dravid, he does a well left, which is to say, but this is not the appropriate manner or the appropriate matter in which this issue must be undertaken. I was actually surprised because there couldn't have been a better case for addressing this question, because the basic question was, if the Shariat Act merely codifies existing practices, that means Shariat Act is giving effect to rights under Articles 25 and 26. So even if the Shariat Act were to be removed, those rights under Articles 25 and 26 would have continued. The Shariat Act was not changing the position. It was merely giving a legislative recognition of the existing position or the pre-existing position. Can such a legislation, which merely codifies existing personal laws, be treated as law for the purposes of Article 13 was the central question that was being raised. Because if personal laws in the absence of state action cannot be decided upon by the judiciary, if the state action is a merely artificial recognition of an existing practice, does it make the state action and therefore the personal laws the subject of judicial scrutiny under Article 32?
That is Narasu.
So that's where the question was. So that question has not been answered. So according to me, Shaira Banu has left certain unanswered questions. And unless and until those questions are decided by the 9-judge bench, according to me, in terms of what is the relationship between religious practice, state action, and judicial intervention, unless these three dots are connected, I think we are operating in a complete state of limbo. And my existing suggestion is that the essential religious practices test is perhaps the worst test, or perhaps the worst interpreted test, because that test was actually carved out in the context of HRC legislation and not in the context of deciding the constitutional validity of a religious practice. That test was evolved only to understand what is the meaning of secular activity associated with a religious practice within the meaning of Article 25(2)(a) in the context of the 1951 HRC Tamil Nadu legislation in the Shirurmat case of 1954. So that test has been subsequently applied in the Dawoodi Bohra case. It has been applied in other judgments as well, completely forgetting the context in which that particular case had evolved. In fact, sir, this is a factual information. During the course of my arguments in the Sabarimala case in July 2018, before the Constitution bench, this was the first question that Justice Chandrachud put to me, asking me whether you believe that the essential religious practices test can be applied to religious practices under Article 25(1), because that test has been evolved under 25(2)(a). That was the very question that was put to me by Justice Chandrachud. So my point was, the judiciary has only two options. Either try and apply a pre-existing test and create a justification for it under 25(1) as well, or please accept that you are in uncharted territory, that you have no precedent to go with, and therefore you have to lay down the law. Okay. So I basically suggested that either you have to extrapolate and apply a test under 25(2)(a) to situations under 25(1), or you have to create a new test under 25(1), which is why if you read Justice Chandrachud's opinion in the Sabarimala 4-1 judgment, there is a very clear discussion on the way forward. Okay. And in that particular discussion, Justice Chandrachud effectively rejects the application of the ERP test for situations under 25(1). Okay. So my basic answer is, anything that is connected to religious laws or let's say personal laws and which has a bearing on personal activity effectively falls under the realm of 25(1), not under 25(2). Okay. Now, the only handle that the state has under 25(2) would be the handle under 25(2)(b). And let me just read out that portion where it says, nothing in this article shall affect the operation of any existing law or prevent the state from making any law providing for social welfare and reform. And this is effectively applicable to communities across the board and not just to one particular community, because the subsequent portion of opening up temples for all communities is only for Hindus, but public welfare or social welfare and reform is applicable to all communities. Now, that means the state will have to first create a reasonable justification as to how unifying this translates to reform. And you have used the word intra-religious reform, so I need to just highlight this here. Sir, the word reform, in my humble opinion, is a slightly loaded word, and for a different reason.
Of course.
Because reform translates to identification of a challenge or a problem. Okay. Reform means you're admitting that there is a problem.
Yes.
Okay.
Yes.
And when you say that there is a problem, I need to hear out the articulation of what the problem statement is. Okay. Because you see, the modern tendency is to treat everything that has come from the past as the subject of reform. And I fundamentally disagree with that. Okay. It can't be our case that something that has survived for 6,000 years is necessarily therefore outdated. Time is no proof of whether something is good or bad. I can't use 5,000 years to actually say therefore it is good, nor can you say it has been there for 5,000 years. How can it survive now? Because I keep hearing this constant argument, how can you argue this in 2021? So I'm saying, so should I argue this in 2050? What difference does it make which year we are in? Okay. So to me, whether it's the 21st century or the 22nd century, doesn't make a difference. The test is always this. What is that specific situation which according to you has led to an anachronism in a law, saying that it is outdated? The moment you do that, I don't even need a formal structure. My way effectively tells me, the Smriti tells me, do away with it. As simple as that, right? So then what would be better is an alternative structure. And that intra-religious reform, which is why I said I agree with the suggestion, I disagree with the basis. The intra-religious reform, who can undertake it? Only a person who is qualified to speak on the Shastras, who is qualified to speak on Dharma Shastras, who is qualified to speak on Smritis can undertake that particular activity in terms of what is the traditional way of reform. Because I believe that tradition itself holds the key to reform. And where tradition believes that something deserves to be junked and has no place in an existing society, it automatically creates a room for itself. And that is why the concept of achara, sampradaya, and smriti work together. Now, here's the simple question. I, as a practitioner of civil commercial law, constitutional law, and perhaps another area of law, if tomorrow the government decides to ask my inputs on reform to criminal law, I will say, I don't know. I'm not the best person for this. Please don't come to me. Please go to somebody like Mr. Siddharth Luthra or any other criminal law practitioner. I'm not in a position to comment on this particular subject for want of experience and practical knowledge. Why do we fail to give the same respect to people who are authorities in dharmashastras, in smritis, in personal laws? I would be very, very comfortable if the government were to actually invite experts on this particular subject and present their case to them and convince the traditionalists, so to speak, that this is why we believe that a reform is meant to be carried out. Okay. Because this tussle between modernity and tradition is bound to continue for the rest of, for eternity. There is no doing away with it, because every successive generation thinks that the previous generation was a bunch of idiots. Okay. So that effectively is something that I fundamentally have to disagree with, because evolution is not moving from stupidity to intelligence, but it is moving from a lower truth to a higher truth. Something which you previously assumed to be true is no more relevant. That is the simple way forward. So I need to have a very clear presentation of the case statement or the problem statement as to what is the subject of reform and what is the case made out for reform. When I understand that particular subject, then I'm happy to effectively say, now let's speak of solutions. Sir, you're on mute, sir.
One last sentence. I did not use the word outdated and all. What I say is, whether such a practice, many practices may not be ERPs at all. They have no place at all in the religion. What I say is, not because of their outdated, they have no place in a civilized world. I think you have heard the word of Madesnana in Kuke Subramanya. Have you heard of this practice? Yeah.
Yes, I've read the judgment of the Karnataka High Court Justice.
Such practices have no place in a civilized world. That is all I say. Nothing about time gap, nothing about outdated thing and all. That's all I say. In a civilized world,
can I comment on that practice if that's okay?
No role to play. A parliament does not need a reason except 25, but a legislation can have some basis, like manifest arbitrariness, which Justice Nariman tried in McDowell and succeeded in Shaira Banu. Right. But what I say is, certain practices have no place in a civilized world, and that should be the test. That's enough.
Can I use this example to make a point if that's okay with you, sir?
Yes, certainly.
So
that's the last sentence. I do not want to take it further.
Okay, sir. So over the last 15-20 years, there has been a movement where people who were previously treated or considered as Dalits have become, let's say, Veda chanting priests and Brahmins in several temples. Okay. Now, I am someone who, my caste certificate tells me that I come from the so-called, God knows what they call it, upper caste, general category, whatever it is. I am of Brahmin heritage. I don't know if I'm a practicing Brahmin. I don't know if I'm of anything, but I'm of Brahmin heritage. There is a difference. Now, if I decide to practice that Madisnana with respect to those priests who were previously considered to be Dalits and who are now treated as Brahmins, and I decide to roll on the leftovers of their food in accordance with the practice of Kuke Subramanya, and I'm not forced to do it, and I'm doing so out of my respect for that particular practice and my respect for that particular person, can my independent right to exercise? It can't be interfered with, right?
No, I completely disagree with you. I'm most unfortunate.
Okay, anyway, no, please explain to me why.
Anyway, it's most unfortunate that you even speak on those lines. I'm sorry. Anyway, that's my view.
No. My point is, if I were to do it out of my own volition.
No. See, my own will I commit sati. My own will I commit child marriage.
That's where I have. If I may.
No.
Sati will effectively translate to what kind of harm? Sati translates to a direct express harm. I am effectively saying that I don't see it beneath my dignity.
Disgusting insult to a human person, only because he's Dalit. I end there. Let us not go further. You take it. They take the other questions.
Gentlemen, I'm sorry for the...
Take the other questions.
Just to intervene here.
That's enough. Take the other questions. No problem.
Gentlemen, I'm so sorry for the interference, but I think we'll just push this discussion later so it'll have a good concluding showdown.
Sure.
Sai Deepak sir, if you're okay taking a political question, this person has repeatedly asked it 5 times. So if I may go ahead, sir.
Yeah, please go ahead, please.
You may support the laws that the government in central passes. I'm just censoring the party name here because
Sure.
The central government passes like the CAA.
Right.
However, the UCC is something that you do not completely support. So do you believe that the BJP has failed to justify the need of a UCC as someone as knowledgeable as do not completely support it?
No, see, to effectively say that my position is completely right and the BJP is wrong, I don't even have, I'm sorry to say, but I'm not that arrogant. Okay, I can't even make the statement that just because I disagree with something and therefore it is wrong. All I'm saying is these are my reasons for disagreeing with it. Okay. So far, I have not seen an articulation of any principle or very clear position from proponents of the UCC. In fact, the positions that I took before, I disagree with them for reasons that I have spelled out. I have not seen anything which effectively changes my mind and tells me, for so and so reason, we believe that this must come out. So my support to any particular political institution or political organization, when it comes to the time of elections, is of course built on which of the options is better. But that doesn't mean that I'm going to blindly support every initiative of any government. Okay, I may have voted for a certain government, but I am not someone who effectively believes that because I have voted, I must say yes to everything. In fact, my duty as someone who has voted is to specifically ask important questions. And if I get the answer and I get satisfied, I have no reason at all. Even today, what I'm saying is that I will blindly oppose the UCC. I'm not even making that statement. I need to know what is its impact going to be on my traditions. I am also going to be very, very clear about what is the process that the government undertakes before it initiates this in the reform. Will they speak with us? Will they interact with us? Will they take our opinions or not? That's my limited position. My general position on most issues is always issue-based. Assume for a moment that tomorrow a different dispensation comes about and tomorrow tells me that we will release temples from state control. Will I sit and oppose that particular issue merely because it has come from somebody else? It doesn't make a difference to me. What matters is the issue and the position with respect to the issue.
The next question is by Santosh Haridas.
Right.
Ambedkar ji in his book Annihilation of Caste answers a question which asks, does caste prevent Hinduism from being a missionary religion? What are your views on this?
I've just answered the question because while I deeply respect Dr. Ambedkar's scholarship and erudition, particularly when it comes to economics and law, I'm not sure Dr. Ambedkar's knowledge of history can be completely trusted. Not because Dr. Ambedkar was knowingly saying something false, but Dr. Ambedkar himself, by the time the book ends, Annihilation of Caste, upon his, let's say, correspondence with with Mr. Gandhi, which is clearly captured in the book, when Mr. Gandhi says that your assumptions are based on what authority, can you please cite the pramana or the sources for making the statement that without caste, Hinduism will die, or that untouchability is an integral part of Hinduism? Then Dr. Ambedkar cites Dayananda Saraswati to support his position. And when Mr. Gandhi goes further and says that apart from Dayananda Saraswati ji, which other original sources have you read to make these points? Then you see Dr. Ambedkar's humility coming out, effectively saying, I think I may be wrong on this particular front. I may not be entirely right, but I'm happy to be explained how I'm wrong and for whatever reason. So therefore, Annihilation of Caste as a book is a fantastic read, but statements made by Dr. Ambedkar as part of the book cannot be treated as final when it comes to aspects of history. Okay, there are better trained historians and there are better trained people who have written on these subjects and who are much better positioned to comment on these subjects. Dr. Ambedkar's contributions to Indian Constitution and India's legal structure and architecture is undeniable. There is no doubting it at all. However, to treat him as a historian of repute may perhaps be seriously problematic. That may do injustice to the subject itself. And I don't think even Dr. Ambedkar wanted people to see him as a historian. So the reason why this becomes relevant is some authoritative sources clearly point to caste as one of the structures for turning Hinduism into a missionary religion, because caste was a way of giving space to multiple jatis and their identities and to give them a place in the Hindu society. So contrary to popular assumption that caste effectively kills Hinduism's ability to be a missionary structure, what they have not understood is today you have American Hindus and white Hindus, Russian Hindus, you have Hindus in Europe, and you have Hindus in countries like Ukraine as well. Okay. Have they stopped being Hindus? Have we understood what their caste is? Are we asking them what their caste is? We are not, right? So we have Latin Americans who are Hindus, we have Germans who are Hindus, we have Russians who are Hindus, we have people from America who are Hindus, you have people from UK who are Hindus. Who is asking them their caste? Nobody is asking them their caste. So today, caste has become relevant only for three primary transactions: reservation, marriage, and beyond that, nothing, right? If you enter a temple and if you want to perform any particular ceremony, who is asking you your caste? Nobody is asking any caste. All the four Vedas are available at 250 rupees to 300 rupees online. You can purchase and read. Does anybody ask you your caste before selling those books to you? Nobody is asking that. So if you're interested in reading the Vedas and if you're interested in understanding the Vedas, which seller is asking you your caste before reading these books, right? So the use of caste as a bogey to say caste is the reason that people are not converting, I'm sorry, not opening your eyes to the rest of the world, where several Caucasians and Russians are effectively becoming Hindus thanks to ISKCON and their activities, and nobody is asking them for their caste. Okay, ISKCON must be singularly credited for turning 25 lakh Russians into Hindus. Okay, so when that is happening, to say that no, caste is a problem here, historically there have been several communities who have existed as Avarna Hindus, which means casteless Hindus, Hindus without a caste. Right? So on that front, kindly don't treat Dr. Ambedkar as the authority. With a lot of respect and a lot of humility, I have been deeply appreciative of Dr. Ambedkar's erudition and scholarship and his blunt talk. I have recommended his books over and over again to a lot of people, including Annihilation of Caste. But we must know that a person cannot be an expert in every subject.
But sir, I think before
Naman, I think we can wind up Q&A session. It is already 7:15. Okay.
Yes, sir.
So I thank Mr. Sai Deepak for his very informative lecture and active, this thing, answering all the questions raised by the participants. With this, now I request our Honorable Vice Chancellor to kindly address us.
Thank you very much for giving me an opportunity to listen to the discourse or the lecture or the issues that have been addressed by our lawyer friend Sai Deepak, senior advocate to the Supreme Court. I thank the organizers, the Department of Law or University Law College for organizing this webinar. I was listening to both the pros and cons of Sai Deepak and also Professor S. Basaraj. And a number of issues have been thrown out. So Hinduism has persisted for more than 5,000 years. But whatever they were practicing 5,000 years back, are we practicing now? No. And there are so many things that which we have dispensed because either it does not suit us, or it is because of our health, or it is because of technology, or it is because of cultural convergence, or because of property rights, or because of inheritance, marriage, compensation, polygamy, polyandry, whatever is the thing, or Madhyasnanavai as in Kukke Subramanya, whether it is a Shabanu case, whether it is Sati or child marriage or Sabrimala case, we have seen that the society is evolving. It is evolving to take the good things and remove the bad things. That is what is going to happen if you are trying to implement the uniform civil code. The uniform, whatever you try to, prescribe to a civilization, it will not simply accept if it is bad. If it is good, it will definitely be accepted. So what I suggest is that there should be brainstorming session between the dharma adhikaris, the lawyers and everything, and come out with solutions. So it is not just a one fit size for all. It is that we have to see that many bad things are there in each and every religion. So it is distorted actually. All religions have the same fundamental concept. You should be truthful, you should be honest, you should be helpful, you should serve people, and this type of thing. But you must allow every person to practice whatever he wants. We should not violate the fundamental freedom or right of a citizen. But we have seen that all developed societies are moving towards some type of uniform structure. That is, that's why it is called uniform civil code. It is not trying to interfere into the personal rights of a religion. I don't think anybody will ask you, okay, don't pray to Krishna or pray to the Rama. That is not the thing. But it comes to, once he comes out of his house, he must follow the same rule of law with respect to property rights. For example, child marriage, it should be banned. For example, sati, it is a wrong thing to happen. And for example, property, it should be shared among all family members, whether it is a daughter or a son. This type of regulation should be brought through the uniform civil code and not to the personal, belief and faith of a particular god or religion. I do not want to talk much because there's lot of things to be spoken, and it is a controversial subject in which we require to discuss further, and many more years I think will be spent on bringing this uniform civil code. But I feel uniform civil code should have two aspects. One, it should not touch upon the personal aspect of a private right of a citizen. And second, whatever is required for the society to progress with respect to technology, with respect to prosperity, with respect to health, that should be preserved. So that should be the function of the Uniform Civil Code. I rightly agree with Sai Deepak that a lot of discussions are required, brainstorming sessions are required. And also say that even a few points which has been given by S. Baswaraj, that should be dispensed of. And intra-religions discussion, yes, it is necessary to bring good in the society. So thank you very much for giving me an opportunity to speak just for 1 or 2 minutes, because I am not an authority. I am just a student of law in 84 and I have not practiced. I am a computer science engineer and basically thought that I should know law of the land. Just right, ignorantia juris non excuse. Just for that one word, I just took law degree, and today here I am as a vice chancellor and trying to encourage all the departments to do this webinar, and it has been really fruitful. Thank you very much, and thank you Suresh, and thank you
sir.
Dasrat, thank you Sudesh, Satish, Jyoti, and and finally I thank Sai Deepak for his enlightening lecture, because you must be given freedom of criticism, you must be given freedom of expression, and you must be given freedom of even discussing with others, even with enemies and friends and everybody, and then coming at a good solution for the society. Thank you, one and all.
Thank you very much, sir, for your enlightened remarks.
Thank you very much, sir, for impeccable words. Raindrops may be little in shape and size, but their continuous fall makes a river overflow. Remember, small consistent efforts makes massive changes in life. With this, I announce the next event of University Law College Alumni Association, Bangalore by Shri Sandesh J. Chowta, Senior Advocate, High Court of Karnataka, on the topic Inherent Power, the superlative feature in criminal law, on 14th August 2020. That is tomorrow at 5 p.m. Meeting ID is shared on the screen. Kindly log in tomorrow. And now I announce the next event of ULC Special Lecture Series with Dr. Pinky Anand, Senior Advocate, Supreme Court of India and former Additional Solicitor General of India. Dr. Pinky Anand has graduated from Harvard Law School a versatile, multifaceted person, social activist, a leading lawyer in diverse fields. Our accomplishments extend from legal expertise to media to politics to social activities. Madam will be discussing regarding the need of strengthening animal cruelty laws in India. The topic is the need of the hour, which I'm sure Madam will give deep insights and will be very useful for all. So grab the opportunity for enhancing your knowledge. I request all the participants to join us on 18th August 2020 at 4 p.m. Next, I invite Mr. Ajit Gigi, student of University Law College, to deliver vote of thanks. Over to you, Ajit.
A very good evening to one and all present here. I, Ajit Gigi, on behalf of University Law College and Department of Studies in Law, Bangalore University, deem it my honor and privilege to render the vote of thanks. First and foremost, I would like to thank our special guest, Shri J. Sai Deepak, Advocate, Supreme Court of India, who, despite his busy schedule, took the time to deliver a special lecture on the issue of Hindu Code Bill and Uniform Civil Code in ULC Special Lecture Series and intellectually address the participants. Thank you, sir. I would like to express my heartfelt gratitude to our patron for the event, Professor Dr. K.R. Venugopal, Honorable Vice Chancellor, Bangalore University, for gracing this event and providing his constant support and guidance in all our endeavors. I would now like to thank Professor Dr. Suresh. Thank you, sir.
Thank you.
I would now like to thank Professor Dr. Suresh V. Nadagaudar, Honorable Principal, University Law College, Bangalore University, for his instrumental support and guidance. Thank you, sir.
Thank you.
I would also like to thank Professor Dr. N. Dasharath, Honorable Chairman, Department of Studies in Law and Dean Faculty of Law, Bangalore University, for his guidance. I thank all the faculty members for their constant support and encouragement in every field. I would like to thank the Student Organizing Committee for the diligent efforts, making sure that this lecture was conducted in a hassle-free manner, and congratulate them for the success of this event. I would also like to extend my heartfelt gratitude to all the students and participants in the lecture series for turning up in huge numbers and making this a grand success. Thank you, one and all. Namaste, Jai Hind.
Okay, thank you very much. Thank you all.